Ses deneme, ses kontrol. Bir tamam hocam. Siz ses deneme
test. Orada.
Merhabalar hocam. Var mıdır bir isteğimiz?
Şöyle bir şey yapalım mı? Şu sesi çok iyi oldu şu anda. Nedir bu?
Turn off my camera.
Ses. Ses deneme. Ses deneme 1, 2, 3, 4. Ses deneme. Ses deneme birinci. Ses deneme. Evet, duyuyorum. Geliyor. Benim sesim nasıl geliyor size? Duyuyorum.
Tamam.
Gönderelim. Devam et. Dinliyorum ben sizi. Birinci kanaldayım. Evet, duyuyorum.
Ses
Tamamdır,
deneme,
teşekkür
ses
ederiz.
kontrol. 1, 2, 3, 4, 5 ses deneme, ses kontrol.
Yükseltelim.
Pazartesi, salı, çarşamba, perşembe, cuma ses deneme, ses
Yükselttim şu
kontrol.
anda.
1, 2, 3, 4, 5
Yükselttim. Tamamdır.
ses deneme, ses kontrol.
Ben
1,
teşekkür
2,
ederim.
3, 4, 5 ses deneme, ses kontrol.
Öğlene
Pazartesi,
kadar
salı,
buradayım.
çarşamba, perşembe, cuma. Çok ses deneme. Ses deneme, ses kontrol. 1, 2, 3, 4, 5, 6, 7, 8, 9.
Tamam.
Duyuyorum sizi. Şu an salon içi test alıyoruz.
Dur.
0-1-2 bir deneyelim mi? Karışıyor böyle.
Nasıl yani? Nasıl bir ayar? Tam oradan yükseltecek. Yok canım, oradan yükseltecek. Şu an yüksek sesle yapmıyorsun.
Hey ses deneme, ses deneme 1 2 3 4 ses kontrol. Hey ses deneme, ses deneme, ses kontrol deneme 1 2 3 4. Ses deneme. Ses kontrol deneme 1 2 3 4 ses deneme. Hey ses deneme. Şu an yayına gelen kablomu sökmüşsünüz ki zaten.
Şeyden gelen. Bak burada bu var.
Alayım mı onu? Bir kere şurada dinleyeceksin. Ses deneme 1 2 3 4 ses kontrol. Hey. Ses deneme, ses kontrol deneme 1 2 3 4. Ses deneme. Şu an oraya ses geliyor. Direkt kulaktan da değil mi? 0. Ses deneme 1 2 3 4 ses kontrol. Hey ses deneme.
Şuradan da çıktık mı? Çıktık. Şu an gelmemesi için bir birim yok ya.
Hadi.
Bir daha
Ses deneme, ses kontrol deneme 1 2 3 4 hey. Ses deneme. Ses kontrol deneme 1 2 3 4. Ses deneme, ses kontrol. Sesi açık mı?
Ses bitti.
Bu açık herhalde. Tamam mı?
In many countries of the world, people want to believe that their are looking for a justice system that provides guarantees for them. For the Sustainable Development Goals of the UN, we see access to justice as one of the main objectives. Human rights mechanisms worldwide, academicians, jurists, activists, and civil society organizations are trying to have access to justice for those who are most vulnerable, and they are putting pressure on states in order to enable this. And this struggle is for access to justice, for the accessibility of services, and also it is not limited to legal aid mechanisms. It aims at having equality. Equal access to justice, supremacy of law, and making the environment fair for everyone is the aim. To information and to policies, we have to have access, and there needs to be a sustainable justice system that would bring the equality a step forward. For disadvantaged groups, we have to strengthen the access to justice, and this is one of the main axes of our struggle. Because of their different characteristics, the existing justice system might not be available to these populations. As an association, we wanted to engage in this project in order to eliminate inequalities and in order to strengthen the roles of bar associations. Throughout these 2 days, we will have different groups covered, and we will discuss equality and justice in the context of different groups. And we will be hearing different presentations. We hope this conference will pave the way for different discussions and to the betterment of justice for different groups. And lastly, for the realization of this conference, I would like to thank our project team, and I would like to thank the researchers who have sent the presentations to us. I would like to thank the interpreters, the technical team, and I would like to thank Atılım University and Union of Bar Associations of Turkey, and I would like to thank the Turkey delegation of EU on behalf of myself and my association. Thank you very much.
Şimdi konuşmasını yapmak için
Now, I would like to invite the Dean of the Faculty of Law of Atılım University, Esra Gül Dardahan, kibar. Distinguished guests, distinguished participants, in this conference on the right to access to justice in law, it is a great honor for me to speak to you in the opening session. This is a symposium organized by the Turkish Bar Associations Union, Atılım University, and the ESİD. This Article 36 of the Constitution and all the different legislation and conventions internationally brings guarantees with respect to the search for justice. But this really depends on many different conditions. The right to go after one's rights is really realized through the access to justice. All the rights that we have because we are humans, all the core rights, and of course among them there exists also the right to access to justice. If the right to access to justice does not exist, then we cannot really materialize those rights. It was so clear in the presentation of the president of the Equal Rights Association, saying that this is really the whole adventure of humanity, the effort to reach justice and freedom. Really, I don't, have much to say apart from that. It's always the question of what can I do for the rights of people, for the rights of humans? What is the theoretical foundation of this right of access to justice? There are many different conditions, many factors play a role in the realization of this right. Of course, in the Constitution, in the international conventions to which states are parties, and in international human rights conventions, it is very important to recognize this as a right. I talked about Article 36 of our Constitution, the right to a fair trial. The Article 6 of the European Convention of Human Rights is very important. In the jurisprudence of the European Court of Human Rights, it says this is the essence of the democratic order of society, the access to courts. Without that, a democratic society is not possible. So we have problems if we don't have this access. That's why all the rights to which humans are entitled as humans and the concretization of these on the basis of the right to look for one's rights, this only becomes possible when the right to the access to justice is materialized. Of course, the jurisdiction of courts is a very technical matter. I am in international law, and there are certain questions whether Turkish courts are have a jurisdiction in this or that area. A respondent in a case, in a trial, should not be taken to a court where they are very weak. On the other hand, the person who is the plaintiff, whose rights they think have been trampled upon, they have to have access to justice. Now, this is a very technical matter, as you can see, but it really is very operational in the access to justice. Well, I do hope that you forgive me for this, partial attitude with respect to my own domain, my own area of law. Well, courts are, of course, the concretization of justice, where independence and impartiality are very important. And on the other hand, there are, of course, the costs that you have to incur in order to go to court. Will I be able to really defend my case in the best manner possible, or will I have to pay in the end all the costs of the court process? So people may refrain from going to court. There are, of course, disadvantages. One of the sessions is on these disadvantages. How can they, in concrete terms, have access to courts? For instance, judicial aid. Well, the president of the association also talked about this. There are certain rules, and certain institutions that regulate these, and how do they operate? So can people have access to justice thanks to these institutions? For instance, one of the realities of our day is immigration. A person who has taken shelter in another country in order to save their lives, can they have access to justice? In the same manner, in the operation of the right to access to justice, do bar associations and NGOs work in a proper manner? Well, we see that during these 2 days, the question will be examined from every different angle possible. So this is a very important meeting. The fact that this conference has been organized in this moment in time is very important. The fact of being here is very important for me. Mine is just an opening speech. First of all, I would like to thank the Association for Equal Rights who have organized this conference, and all the academics who are sharing their ideas with us, and those people who come from within the practice of law. I would like to thank them all, and I greet you all with great respect. I do hope that I haven't spoken too long. Thank you.
Now I would like to invite Erinç Sakan in order to deliver his opening remarks. Good morning, everyone. I would like to greet all the participants on behalf of the Union of Bar Associations of Turkey, Association for Monitoring Equal Rights, Atılım University, and bar associations are conducting a project together, and we are here today for realizing one pillar of this joint effort. It is a weekend and it is the morning hours, and instead of resting together with your family, you have joined us to discuss this very important topic together. I would like to thank each and every one of you for this effort. We will be discussing one of the most important problems of Turkey. Right to access to justice is one of the most important problems. If we were to discuss economy, most economists will focus on the supremacy of law and also talk about the right to access to justice. And for the solution of the problems, we have to have the right to access justice. This important topic will be discussed together with very distinguished speakers, and I hope we will have a roadmap in front of us after this effort. In fact, both the data from the Constitutional Court and European Court of Human Rights show us why this topic is so important. And individual application system started in September 2012, and we have the data from the Constitutional Court regarding the individual applications. There have been 320,000 applications that were covered, and in 1/3 of such files, there was at least one right violation. And most of these violations were related to access to justice. And 60% of these were violation of being tried in a reasonable time, and 1% were related to effective applications. And in cases where a violation judgment was given, more than 70% was related to right to access to justice. And this is reflected to the statistics by the European Court of Human Rights. And in January 2022, the statistics of the previous year were reported, and there were 76 judgments about Turkey. 31 was on the freedoms of expression, and 29 of them were about the security and freedom. And when we add to these the other violations, we see that in 2021, 1/3 of the violation decisions were about access to justice. And right to access to justice, length of the trial, not carrying out an effective investigation, and not executing the judicial decisions add up to 2,000. And it is 2 or 3 folds of the closest right category. And it is very obvious what this shows us. Access to justice might be the most important problem in Turkey. And this is a problem that is related to all other areas for vulnerable and disadvantaged groups, as well as for people who are discriminated against. This is an important area. And also, this is closely related to the impartiality problem in Turkey. Access to justice should be dealt with together with impunity, and there is a grave problem of impunity which is not reflected to the statistics. After the right violations experienced by individuals, there is the feeling of not being able to have access to justice, which brings a big insecurity and not believing in the justice system in the country. In that regard, Association for Monitoring Equal Rights and Atılım University have partnered, and we are working together to this end. And here we have a 2-day conference, and we are inaugurating it. And during this conference, we will cover all the dimensions of the topic. We see that we have a packed agenda covering the different dimensions, and international experiences will be shared, and alternative mechanisms in access to justice will be covered. And we will I hope we will hear solution methods presented. With these ideas in mind, I would like to greet each and every one of you with respect once again, and I would like to thank all the distinguished speakers who will be contributing with their presentations. And I hope these will be beneficial for solving the access to justice problem in our country. Thank you very much.
Adalete erişim hakkının hukuki çerçevesi isimli ilk oturumun moderatörü olan Sayın Doçent Doktor Çiğdem Sever'i.
I would like to invite Associate Professor Çiğdem Sever, who will be the moderator for the first session, Legal Framework of the Right to Access to Justice. The first speaker will be speaking online, Rojin Pillay, who is the director of the Europe and Asia, Central Asia Regional Program of the International Commission of Jurists. I would like to invite.
Çok özür diliyorum bu teknik detay için ama şunu almamız herkes için daha kolay olacak. Daha konuşmak açısından. Ulaş yardım edeceğim. Olamadık. İlk oturumu olmanın acemiliğini yaşadık biraz. Evet, hepiniz hoş geldiniz. Bugün burada olmak gerçekten çok mutluluk verici. Çünkü gerçekten bence pek çok konferansa göre daha farklı bir ortama sahibiz. Çünkü
Welcome everyone. This is a very interesting meeting. We have people from different areas, academics and jurists and all kinds of people from within practice, the practice of law. In our first session, as was said, was on the legal framework of the right to access to justice. The best moderator is the one who speaks least, and therefore I would like to introduce you, first of all, the speakers. Our online speaker is already connected, Rojin Pillay. She's from the International Commission of Jurists. She's the director of the Europe regional program and Central Asia as well, the interpreter adds. She is very important in the areas of human rights and all the different institutions that regulate human rights internationally. In Ireland, she was active as a consultant in Parliament and also was represented certain bodies. She's also a lawyer. I would like to welcome her to the program. The title is International Standards of Discrimination in Access to Justice. Yes, welcome, the floor is yours.
For inviting me to speak at this conference. And I'm really looking forward to also hearing the other presentations. So I'm going to speak fairly briefly, outlining some of the relevant international human rights law standards that govern this area, in particular relating to equality and non-discrimination in access to justice. Sorry, I hope you can hear me well.
Umarım beni duyabiliyorsunuzdur.
So I know that several aspects of these standards will be addressed in more detail in future presentations. So here I'm going to give the broader framework. And I want to begin by saying that, as I think some of the introductory speakers have also mentioned already, access to justice is an idea that's really central to the idea of effective guarantees of human rights. Central to this is, I'm sorry, I think there may be some problems with the sound. Can you hear me?
Sanıyorum bir sorun var diyor konuşmacı, çünkü muhtemelen bizim sesimizi duyuyor. Bizim kendi sesimizi duyduğumuz gibi bir sorun var yani seste.
Çalışmıyor. Ha, şimdi çalıştı. Yes, we can hear you. We can hear you very well. There's no problem.
Okay, I'm sorry. I'll keep going. So I wanted to start by saying that the idea that rights should be practical and effective, not merely theoretical and illusory, is an idea that's central to human rights law. It's an idea that the European Court of Human Rights, in particular, has used very thoroughly in its jurisprudence. And this really is what the rights of access to justice are about. They're about making the guarantees that we see in international human rights treaties that can often seem very remote from the realities of those who are struggling to uphold their human rights. But access to justice standards seek to close this gap, seek to make rights a reality through the justice system. And they seek to do that on an equal basis for everyone. So access to justice is therefore a key component of the rule of law in any legal system, and is also an essential condition for the realization of all human rights in practice. And it's really difficult to speak about access to justice seriously without speaking about non-discrimination and equality. It's been well noted, for example, by the United Nations Special Rapporteur on the independence of judges and lawyers, that the right of access to justice includes the right to effective judicial protection, to fair trial or due process, the right to an effective remedy, but also the right to equality. So equality is central and a necessary element of access to justice. And of course, justice systems in most societies operate in contexts where there are structural inequalities that affect the court system as much as they affect other state services and institutions. And it's those who are most marginalized in any society who are most likely to struggle to access justice, who face legal obstacles, educational and cultural barriers in accessing justice. Those barriers may range from violence against those who seek to access justice, to stigma, to poverty, to practical questions of having to travel a long distance to a court building or difficulties in accessing lawyers. And what equal access to justice requires the legal system to do is to adapt, to consider the different perspectives of those who use the justice system and to make positive efforts to redress these inequalities so that justice and remedies are real, a practical possibility for everyone. So international law recognizes this. It has built from the guarantees that we have in international instruments of the right to fair trial and other procedural rights, as well as guarantees of non-discrimination and equality, and has built a jurisprudence around these to guarantee standards and make recommendations for achieving equal access to justice. And in looking at the international law framework on this, it's worth, first of all, taking stock about how access to justice itself is protected in international human rights law. And few of the human rights law treaties that we have expressly protect a right called access to justice. Instead, it's generally expressed as a compendium of several rights. Of course, the right to a fair hearing, as guaranteed, for example, under Article 14 of the International Covenant on Civil and Political Rights, or Article 6 of the European Convention on Human Rights. Also, the right to an effective remedy, as guaranteed under the International Covenant on Civil and Political Rights, Article 2.3, Article 13 of the European Convention. And then we also have procedural rights as part of the substantive rights, such as, for example, the right to life, amongst others, where we have the duty to investigate, the duty to bring, in appropriate cases, perpetrators to justice. These all also contribute to protections for access to justice. And in addition, there are treaties that establish specific rights of access to justice for certain groups and to non-discrimination in access to justice for people belonging to those groups. Notably, in the Convention on the Rights of the Child, we have a number of very strong guarantees relating to the access to justice for children, including the right to be heard, the right to a fair hearing. We'll hear more about that from other speakers later. In the Convention on the Elimination of Discrimination Against Women, we have rights of equal protection, which have been elaborated by the committee under that convention, that have given us a lot of very detailed standards on access to justice for women. Under the Convention on the Rights of Persons with Disabilities, we also have rights of equal access to justice for persons with disabilities. The Convention for the Elimination of Racial Discrimination guarantees equal treatment before tribunals, as well as effective remedies. And the Convention on the Protection of the Rights of Migrant Workers and members of their families also guarantees equal access to protection and remedies and equality before the court. So this is the general treaty framework that we have. And the core elements of rights of access to justice that we have under these rights are, first of all, as part of the right to a fair hearing, we have the obligation that there must be access to a court that is independent and impartial. So this was alluded to also in the introductory presentations. Having an independent and impartial court, a court that is institutionally independent, as well as a judge that is personally independent and impartial, this is a necessary condition of access to justice. But in the context of looking at disadvantaged groups, we also have to remember that an independent court is a court that is sensitive to the needs of different groups. It's a court that is gender sensitive, that is gender balanced, and that reflects the diversity of the society in which it adjudicates. And this has been mentioned, for example, by the Special Rapporteur of the United Nations on Judges and Lawyers, who has stressed the importance of courts reflecting the diversity of societies as something that is essential to building trust in the judicial system and ensuring that women's or other groups' experiences and specific needs are taken into consideration. And secondly, the right to an effective remedy requires access to court. And there's extensive jurisprudence of the European Court of Human Rights, for example, on what this means in practice. It's not an absolute right, but limitations on this right mustn't impair the very essence of the right. They must be proportionate, and they must not be discriminatory, of course. And there mustn't be arbitrary or discriminatory or unnecessary procedural barriers. So this involves all of the issues we think of when we think of access to justice: unreasonable time limits, for example, excessive court fees, language barriers that are not addressed through interpretation or translation of documents. And of course, such barriers often affect those who are most marginalized the most. And legal aid, of course, must be provided where it's essential and effective for effective access to court. And again, this needs to be assessed with regard to the particular circumstances of the individual litigant. So issues of equal protection are very relevant here. And there must be a hearing that respects equality of arms and an effective and prompt execution of judgments, of course. And then with regard to the right to effective remedy as guaranteed in international human rights law, this is also essential for equal access to justice. And one important point that has been established by international human rights bodies, including, for example, the UN Human Rights Committee, has remarked that remedies must take into account special vulnerabilities of the people who seek them. In General Comment 31, the committee stressed that remedies should be appropriately adapted so as to take account of the special vulnerability of certain categories of persons, including in particular children. So then I want to come to the second part of my presentation, which is just to look briefly at the guarantees of equality and non-discrimination, which of course have to be looked at along with the rights of fair hearing and effective remedies. Like all other rights guaranteed in international human rights law, these procedural rights are subject to these guarantees of non-discrimination. We have these guarantees of non-discrimination under Article 2.1 of the International Covenant on Civil and Political Rights, and that guarantees that the states must respect and ensure to all individuals the rights under the covenant without distinction of any kind, such as race, color, sex, language, religion, political or other opinion, national or social origin, property, birth, or other status. We have similar guarantees in relation to economic, social, and cultural rights under the Covenant on Economic, Social, and Cultural Rights, and of course, under the European Convention on Human Rights. And I read out the grounds of discrimination, which I know we're all very familiar with, but just to remind us of them, and to mention also that this list of grounds of discrimination, of course, is not exclusive in terms of international human rights law, and a much broader list of characteristics are also accepted as potentially grounds amounting to prohibited discrimination. For example, discrimination on grounds of sexual orientation and gender identity has been found by the European Court of Human Rights and other international human rights bodies as a ground of discrimination, and quite a rich jurisprudence has been developed on discrimination on grounds of sexual orientation or gender identity. The European Court of Human Rights has also clarified that differences in treatment on grounds of immigration status fall within the Convention, including in relation to discrimination in the justice system. For example, There have been cases where legal aid has been refused on grounds of immigration status that have been found to raise issues under the convention. And other international human rights bodies have followed a similar approach. And I think an important aspect of the international human rights law concerning non-discrimination is the existence of both negative but also positive obligations on states to protect rights, not only to respect, but also to ensure, to protect and fulfill equal protection for all. This is particularly relevant to issues of access to justice. And it's recognized that states may have to take positive actions to achieve substantive equality between individuals. States have obligations to protect not only direct discrimination, where a provision explicitly discriminates or clearly discriminates against one group, but also indirect discrimination, where there's an apparently neutral provision, criterion or practice that puts one person with a particular characteristic at a disadvantage compared to others. And in these circumstances, a state may need to take positive action to establish equality. And this has been this need to take positive action has been particularly emphasized, for example, by the UN Committee on the Elimination of Discrimination Against Women. And they said it's not enough to guarantee women treatment that is identical to that of men. Rather, under certain circumstances, non-identical treatments of women and men will be required in order to address the differences that exist within the society. And in the field of access to justice, this is an important principle that international human rights law requires the state to consider the specific needs and circumstances of particular groups in order for them to be able in practice to access justice and to take particular measures to address those needs. And for example, a very helpful guide through the principles that apply here, I think, is the Committee on the Elimination of Discrimination Against Women's General Recommendation number 33 on women's access to justice, where they identified 6 interrelated components of ensuring equal access to justice for women. And these are also relevant, I think, for equal access to justice for other groups. So first of all, they identified justiciability, which is the ability and empowerment to claim rights as legal entitlements. Secondly, availability, the establishment, maintenance, and funding of the courts. Thirdly, very important, accessibility. So is the justice system secure? Is it affordable? Is it physically accessible? Is it adapted sufficiently to the needs of women or another group? Next, good quality. So the quality, the efficiency, the competence, the also gender sensitivity of the justice system, accountability, and access to effective remedies. And the committee has then set out many practical recommendations for how these principles need to be realized in practice. It's also worth looking more, and I know there will be more discussion on this, at the provisions of the Convention on the Rights of Persons with Disabilities, which has particularly strong protection concerning the need to take positive steps to ensure equal access to justice for persons with disabilities, in particular under Article 13 of the Convention, which requires states to ensure effective access to justice on an equal basis with others, including through the provision of procedural and age-appropriate accommodations. So the need, again, to take positive measures of accommodation. And states have an obligation to promote appropriate training for those in the justice system to equip them to do this. And these principles have been further elaborated in a very helpful set of guidelines prepared by the Office of the High Commissioner for Human Rights, which International Commission of Jurists also endorsed, the principles and guidelines on access to justice for persons with disabilities, which elaborate further on the need to make procedural accommodations in various aspects of the justice system. So I won't go I won't go much further because I see the time is running on. Of course, there's many issues to discuss in all of this. I would just like to conclude by stressing the value of this international human rights framework for practitioners at the national level. These international instruments and recommendations that we have are only really valuable if they are used in practice by national practitioners, by lawyers pleading cases in court, by NGOs and civil society in their advocacy nationally. We need to use these standards to hold the state authorities to account in all states, and that is done through pleading them in court, through informing the national case law and jurisprudence with these standards, and through advocacy to ensure that the recommendations of international bodies are brought to the attention of national authorities. So I hope that they can provide a helpful framework also for thinking through some of the issues that will be discussed in this conference over the next 2 days. Thank you very much.
Thank you very much, and also for your timing. Thank you. Evet, uluslararası anlamda bir giriş aslında bizim için çok iyi bir giriş.
It's a very good introduction for us to give us the international context. Thank you very much. Our second presentation will be by a name that is known to most of you, and this will be by Ulaş Karan. He will be talking about the role of judicial and quasi-judicial mechanisms in access to justice in Turkey. And Ulaş Karan has graduated from Marmara University School of Law, and he had his master's and PhD in the field of human rights. And from 2005, he is working at the center at Marmara University, and he is also a faculty at the same university in the areas of human rights, individual application, the principle of equality, and are his areas of interest. And also he is focusing on areas like hate speech and conducting research on this. And you might know him from his research articles. And he's a member of the Committee on Non-Discrimination, and also he has conducted research in this area. I would like to give the floor to him. Thank you very much. To Atılım University, Union of Bar Associations of Turkey, and Association for Monitoring of Equal Rights. And I would like to thank all the participants for coming here on this very nice Ankara day and sitting here in this hall, which is below the ground. And I would like to thank them for taking this adventure. Organizing such activities during the weekend is good in order to find time from work, but it brings another level of fatigue as you spend all day inside. So we will be talking about the concept of right to have access to justice, and I will be talking about the judicial and quasi-judicial mechanisms in Turkey. If you can open my presentation. So we are talking about ways to seek justice, and there is in fact a division, as you will see on the slides. In Turkey, there is a distinction between administrative courts and others, and there is also the constitutional court. And in the effort to have access to justice, you have to know the divisions between the different courts. And in the last 10 years, there is the Ombudsman's Office and Turkish Agency for Equality, and it is also possible to diversify the environment with other structures. Yet we can mainly talk about two elements. Ombudsman's Office and the Equality Office are not well known in the society, and as jurists and as lawyers, we do not like it very much. However, theoretically, there are other mechanisms like mediation, and in the penal aspect, we are also trying to find solutions through these possibilities. However, theoretically, how these are regulated in Turkey, are they functioning at practical level? I will try to cover these. When we talk about access to justice, we are talking about a procedural problem. And we lawyers usually focus on the process. And when we talk about right to access to justice, we think about having access to certain mechanisms, judicial mechanisms. But today, we know that new groups have certain demands for access to justice, and physical aspects of the topic need to be covered then. And the concept is not only about applying to a court, and it has a wider meaning recently. But in all the instances, it is about having access to mechanisms, and the judgment by these mechanisms being fair or not is another dimension. Right to a fair trial also focuses on the process, not to the judgment, and also talks about the principles being respected in the process. Limitations in the right to a trial, for example, minors and people below the age of, under the age of 18 cannot have this right. And also certain people do not cannot have individual applications. And for people with mental problems, whether they can decide by themselves or whether they can be represented is another topic for discussion. And the colleague after me will cover the rights of people with mental disorders. And this also brings forward the legitimacy of certain practices, and people who have such problems might experience problems in their attempt to have access to justice. And the main problems are related to indirect limitations, like representation by a lawyer. The costs in Turkey are increasing all the time, and when we consider the minimum wage, we can say that the fees are very high. And the time frame. There, in many disputes, there are very rigid time frames, and which might result in loss of certain rights. And as concerns when the time starts and when to make certain applications, this freedom can be limited because of time constraints. and there are limitations for the courts. If you are a civil servant, if you are working in the public sphere, and the figure for this around 3 million individuals, and the administration needs to give permission for a trial, and there is immunity for civil servants, and human rights violations can be conducted by these individuals, and the only exemption is torture. And we see that when the administration does not give the right to try it, we see several examples of this, as we have seen in Bartın mining disaster as well as in Soma. And people who are in charge of these incidents will not be tried, and we will be seeing this. And for people outside of Turkey, these examples do not mean much. However, railroad accidents and occupational accidents that resulted in 300 people dying are examples of this, and also the waste explosion in 1993. In none of these civil servants were tried, and these immunities are very important in the Turkish context. When certain cases are tried, we can see amendments to certain legislations, and the legal struggle extends to years, and you might be in a position to pay significant fees because of the amendments that have taken place during the process. And the legislative organ can come up with such amendments during the process, and not executing the judicial decisions is another topic that is problematic. Either these are not executed, or sometimes there is a new case brought to the court. And I do not remember the name, but there was a deputy provincial educational administrator, and the individual was going to the court and repeating this several times. And this is something that we see quite often in Turkey, the judgments not being effective and not being executed. So what type of limitations do we have? First of all, physical obstacles. And you might have the largest courthouse in the world in Kartal district or Çağlayan district of Istanbul. There are also annex buildings that are built. I know that several similar problems exist also in Ankara and Izmir. So physical obstacles remain, and when new courthouses are being built, this aspect is still not respected, and there are complaints regarding these physical obstacles, and the signs with Braille alphabet are not being renewed, and people with visual impairments are very bothered by this, and signage are kept in their old form, and people do not know which way to go when they have to find their way. And also the Braille alphabet signs in the elevators have not been changed after new buildings were added, because after such constructions take place, people do not think about the need to change the signs in the elevators accordingly. Economic obstacles are very important in a country where minimum wage is 5,500 liras. When you convert this into euros, the fees might seem low. However, compared to the minimum wage, these are very high. There are, of course, legal limitations, and people do not believe in the mechanisms available. In Turkey, the level was very low, and people did not believe in the existing mechanisms. There was a research conducted by the Bar Association of Istanbul, and they were sued because of this effort. And people did not believe in the results, and the researchers were brought to the court. And not having the awareness to use their rights in Turkey, the literacy levels are very low, and people do not want to go to the court. And when we have a look at the figures in front of the courts, we see that around 6 million cases are filed, despite the fact that people are not that willing to do this. And imagine that there weren't any obstacles, the case numbers would have increased, creating a further vicious cycle and making it impossible to cover all these cases. In Turkey, the problem exists for all the groups. I won't be listing all of them, but in a conference of 2 days, it won't be possible to cover the problems of all the groups, but we will be covering the problems of certain groups only. And HIV positive individuals, for example, have very specific problems, but in the hierarchy of inequalities, I believe asylum seekers, immigrants, refugees are the most vulnerable. And at some point, Kurdish people were very vulnerable, and some groups continue to experience problems. However, the refugees and immigrants constitute a population of nearly 5 million individuals, and the chance for these groups to have access to justice is not there, unfortunately, because of several reasons. And as lawyers, when we talk about right to access to justice, there are several problems. UK is one of the worst examples. There is no real budget for legal aid, and it is nearly impossible for poor people to have access to justice. There are only services given by volunteers. We at least have a legal framework, but when you do not have certain procedural guarantees, then there is the violation of the right to fair trial, and this is against the supremacy of law. And at the same time, if you are members of certain disadvantaged groups, and if you are experiencing further problems, this is the violation of the principle of equality. However, there are not many judgments by the Constitutional Court, and this topic is not that much in the agenda, because when you do not have access to justice, it is not possible for you to have access to the Constitutional Court, and unfortunately, these are not brought to higher courts. We are making references to European Court of Human Rights at many instances, and the right to fair trial, or Article 6, Paragraph 1, regarding the administrative trials. We have tragic examples that the court had to accept, and we have very vague expressions bringing obligations to states, And for Turkey, there are tragic cases that you might remember. In 2004, in Istanbul, an elementary school student, there was a break, school break due to snow, and the kid could not go back to his home with school shuttle buses and had to walk, and was frozen to death. And the family, when they tried to apply to the court, administrative courts did not allow for using legal aid, and European courts decided for a violation. And when relatives of an individual who lost his life in Diyarbakir tried to go to court, as the court did not allow for legal judicial aid, the family could not make use of its rights. And there are many sad examples, unfortunately, in Turkish history. And states are not given are given very vague responsibilities, and they say that the judicial system needs to be simplified. And in Turkey, at the theoretical level, there is judicial aid. However, during the last 10 years, you have to pay all the fees concerned ahead of time. And these fees are increasing day by day. And for disadvantaged groups, this becomes a more significant problem. And when you lose the case, you have to pay all the incurring costs. And my colleagues will know that we had law clinics courses, and when we were informing the individuals who applied to us, we talked about fees of 5,000 to 6,000 liras, and this resulted in many people not pursuing this opportunity because they were afraid of the costs, because there were never guarantees that they would win at the court. And when they weigh the amount they are going to pay, it is equal to, and if people go to court because of not being paid the minimum wage, and if you pay more than that amount concerned, it is not worth the effort. And if you lose the case, and then you have to pay about 2 times your minimum wage. And another problem for these mechanisms is that there are criteria like poverty being in play, and many courts do not accept the demands, and there is no shared jurisprudence. And if you lose, then you have to pay the amount. And for foreigners, for example, if Turkish citizens are in Syria, can they make use of the services? If that is true, then a Syrian citizen can exercise the same right when in Turkey. And this makes things impossible for many individuals. And if an individual is victimized because of losing, and then he or she can be exempt from paying the fees. Another dimension is the lawyer, and the bar associations have the responsibility, together with the evidence that you have in hand, the Bar Association can assign you a lawyer free of charge. However, the figures are very low and the fees paid to the lawyers are very low, thereby making the motivation of the lawyers very low, and the results are unfortunately not very successful. The regulation says that the necessary documents are required. Some bars might ask for those documents, some might not. There is not an established system that we can talk about. And will they only ask for the poverty document, or will they ask for others, for example? And this is a regulation I would like to touch upon for foreigners and international protection law. People in for special needs, minors who are not accompanied, or single parents with children, and people who have been abused or sexually assaulted. These people, it says, are prioritized, and people who cannot pay the legal fees can make use of the service free of charge. However, the figures, I need to say, are very low. And for individuals who had made applications for foreigners, it is not really possible to make use of the services. And poverty is one of the criteria, and for individuals to have legal aid. So I will provide an example from Istanbul Bar, which is one of the largest bars, and 890 lawyers are registered. Lawyers with disabilities, 22 such lawyers are also registered. And the only positive discrimination is to have more assignments for lawyers with disabilities. However, they do not prioritize people with disabilities. Children who are victims of violence can make use of this service. There are only 8 centers in Turkey, and these are not physically accessible. We know people who cannot pay for bus fees or bus tickets. They cannot physically access this center and make use of this right. I remember one case. The woman was tied by the husband, and she cannot physically go to the bar. And the lady calls the bar, and luckily she is saved as the lawyer could reach her house. Sometimes having the phone number and seeking for help is difficult. And when we talk about disadvantaged groups, such experiences can be there. And so you see the number of applications are very limited. 13,000 individuals had applied, and 10,000 were assigned with lawyers. And family law and violence against women are areas mostly covered, and very rarely other topics are covered. And this is a very selective approach, as there are limited resources. This is the case. However, the problems are not limited to this. I will skip this part, and for the victims, there is a real problem. There is a significant problem concerning the use of interpreters, and judicial reform does not focus on this topic. Law clinics did not get effective, and many topics and effective information, this dimension doesn't work efficiently either, and many people are not aware of the services available to themselves. Interpretation services have not been standardized, although it is provided at a more widespread level. It is not standardized, and only the lawyers can file the cases. And as concerns the insurance system, I do not know how this target is helpful. However, at least by paying a nominal fee, you can make use of the services of a lawyer. Yet, this wasn't put into practice. And we talk about magic dates, and there is an objective for 2023, and for 2053, another date. I do not know what we can say about access to justice. And I believe there will be updates next year resulting in further 5-year strategies. And the fees paid to the lawyers will be increased, and for mediation, the services will be strengthened. And there is a foreseen cost of 3 million. You cannot even realize one of these with the amount concerned. Resource allocation-wise, we see that this is not realistic at all. If you have a look at the number of cases in a year, it is 6 million, and we have an 85 million population in Turkey, and the legal aid paid per person is 1.6 liras, which is below 10 cents if we convert it into euros. And it is not possible to have this amount help the problems that are concerned. And in year 2008, 3 colleagues, Kalem, Cahit, and Elveriş, conducted this research. Some do not have lawyers as they think it is very expensive, and others think that they can defend themselves. And we jurists find this very funny. Some people think that there is jury system in Turkish courts because of watching US series, and concerning the basic knowledge, they are not knowledgeable. And assuming that you can defend yourself at a court is very naive. And there is a very technical trial process, and in this process it is not possible for an individual to defend himself. I want to talk about 2 agencies. One is the Ombudsman's Office, and the other is the Equality Office. There are many problems. However, you can apply free of charge, and there is no obligation to get aid from a lawyer. However, these agencies are far from international standards, and there are responsibilities they can have at a theoretical level, but at practice, this is not the case. We have a report together with the Association for Monitoring Equal Rights, where you can find the details of the situation. So can we have other means? And the system of mediation is there. However, it extends the time required for the cases, and employers are making the people sign certain documents, and the system is being used negatively. And in certain countries, we see that there are positive results, and it is contributing partially to the solution of the problems. We definitely need significant reforms taking place. So we have to talk about the concept of justice when we cover access to justice, and we have to criticize ourselves. The bar associations focus on the fees of the lawyers, and for those who have to have access to this service, this is not a priority. And there have not been any promotional effort by the bar associations during the recent years. And this also limits the number of applications. And the fees have to be at a reasonable level, and this service, in fact, has to be completely free of charge. This is an area where individuals can have such type of legal aid without paying any fee, and the mechanisms should be faster. And rent disputes are the most popular topics these days, and these might last 2 years. That is the foreseen time period for the identification of rent. And one court talked about 750 days, and this is not accessible for a simple rental dispute. And if this is the case, and although there are procedural guarantees, because of such long time periods, people refrain from going to the court and look for solutions outside the courts. So what needs to be done? Pro bono is a possibility. There will be a presentation on this. There are representatives of civil society organizations. There might be representatives from bar associations. Everyone has her share. One cannot be an alternative to the other, and you can add other mechanisms. Those are not alternatives to the legal aid system. However, in the civilian spheres, like universities, professional associations, everybody should engage in this effort and should do whatever they can to strengthen the mechanisms. And maybe this conference can help understand the roles the different actors have, because we cannot solve this by amending the legislation or by educating the lawyers further, because these problems cannot be brought to the civilian spheres either. So we have to definitely have an integrated strategy together with legal amendments. Thank you very much for your patience. I would like to thank the interpreters for their patience as well. I have been warned because of talking fast. However, due to time limitations, I have to be fast, and we would like to apologize from the interpreters ahead of time. If you have questions and if we have time left, I would like to cover them as much as I can. Thank you.
Konu çok, yani mevzumuz çok, sıkıntı çok. O yüzden böyle.
Thank you. There are so many things to be discussed. Of course, we want to speak fast so that we can say as much as possible, but we will be able to talk about these over time. Let me correct something. Aynur Tuncel Yazgan will be speaking next. She made a change in the title of her speech. She'll be talking about the access to justice of people who have been shut up or are being kept in a closed space. She graduated from Istanbul University Faculty of Law in 1984, has been working as a self-employed lawyer since 1985. She is the founder of the Istanbul Bar Association's Child Rights Center and the Procedural Law Implementation Assignment of Public Defender. Tuncel Yazgan served as the chairperson of the Street Children Foundation Board of Directors and Istanbul Bar Association Fair Trial Follow-Up Center. Thank you. I greet everyone with respect. I was graduated in 1984 and started to work as a lawyer in 1985, I thought I was going to work for children's courts, juvenile courts, but the law was passed in 1979, but no juvenile courts had been established. I was very sad to hear there were none. In 1988, a juvenile court was established, and I was very happy. The martial law courts had been just shut down. The judge who worked for the martial law court was made the president of the juvenile court. We tried to explain to him what juvenile children's rights are, and he explained to us what criminal procedures are. We used to go to the children's in prisons and visit them, and they have problems. They're uneducated. They have problems with their parents. There's poverty. There is no education in sex, and complete intolerance of different sexual orientation. A lot of sexual abuse, but no lawyer, and drug abuse from very early on. So we have been on the field since 1988 in all on-the-job training sessions. We always had the same people, the same psychologists, the same social service workers, the same lawyers, and the usual suspects, we said. Now I'm looking at the situation. My son has autism, so you see, I have to take care of him, so I'm not very involved in civil society, but I was founding president of the Children with Autism. Now it's my daughter who's the president. I am also here in representing that association, but the Association for Equal Rights invited me probably because of my relation with the Commission on Fair Trial in the Bar Association. But this is not really the topic I would like to talk about. One has to be in interaction with practice, and then the services lose in quality as they develop, so one needs a lot of education as things go on, and there's a lot of noise. There are rows that go on, and life goes on, and those individuals who have special needs, we have difficulties in helping them in order for them to express themselves within their own nature on the basis of the principle of equality. We are really helpless. So the speakers have already said how comprehensive this conference is, and there are different speeches which will take up these questions on the different aspects. But let me just say one simple thing about access to justice, the international source. How did this come about? What was the origin? How did it develop? We can only remove confusions that way. When I look at the program, I will be mentioning that, but I haven't seen there, apart from the children's situation, there is nothing on aliens, foreigners. people shut up for mental diseases or drug abuse, or because they are parentless at a young age, or because they were shut up in an institution because of the abuse of their parents. This is not taken up, so this is why I'm talking about this. This concept of access to justice cannot be really grounded in the European Convention of Human Rights or the International Covenant on the Political and Civil Rights. This goes back to the UN Declaration of Human Rights, and of course we have to refer also to the Convention of on the Rights of the Child, and then the European Convention on the Rights of the Child. At the end of the whole program, there will be a presentation on the duties of the bar associations, so they will be talking about this, but I just wanted to remind you that the origin of this concept lies in the United Nations, and it befits the United Nations. The Havana Rules in 1990 have to do with the role of the lawyers, and then there are rules with the rights regarding the rights of people shut up and the security to be provided these people. There is the mention of everyone having a right to access to the services of lawyers who for the violation of rights. If you look at Article 6, Paragraph 1 of the European Convention of Human Rights, you see that the field there is limited. Who a court which has been instituted on the basis of law, in what time, well, in a reasonable, what kind of principles, the right to a fair, court procedure in consonance with the right to a fair trial. Who can enjoy this right? These are people who are in litigation with certain people and have the right to use their rights in access to justice. This has to do with the administration law, but I see a violation with respect to civil law in each event. Can I defend my rights with respect to civil rights here? And they have to prove this. Well, this professor talked about this anyway. But if you look at the Havana Rules, all persons have equal rights. The United Nations established this in the Havana Rules. There are certain instruments and guarantees. CCBE, there is the CCBE. They have recommendation decisions. They talk about access to justice and talk about this as a fundamental right. Well, people will be speaking about this indispensable fundamental instrument. Let me give you a simple example. Ulaş Professor Ulash talked about the bar associations being turned inside with respect to the problems that lawyers suffer from. I wish they could take care of those problems, but let me give you a simple example. As I was coming, I asked the Istanbul Bar Association and Antalya Bar Association. The Council of Europe has had a kind of work carried out on these questions, and we worked together. What was done there was the following. When the Bar Association appoints a lawyer to a person who cannot defend themselves, this was only the official authorities were notified of the existence of this law, of this appointment, but not the person who is whose rights have been violated. This person possibly has been beaten by the police, and they are expecting a lawyer, but although the lawyer is appointed, no one notifies them. So the lawyer is face to face with the conscientious decision to go visit this person. Otherwise, they don't have to. Because of the following accusation, because of what you have done, or because you have been closed up, because you have mental problems, is the expression that they expect. I mean, they want to know and have the right to know why they have been shut up, but this problem has not been eliminated. Now I'm closing this parenthesis, and CCB said that the access to a lawyer is a fundamental right without regard for the economic situation of the accused. CCB says without even looking at their socioeconomic situation. Well, you may be from the Sabancı family, a very rich family of capitalists in Turkey. You may have your plane may simply have had an accident, and you are now in Bitlis and you don't know what to do, so you may need lawyers appointed by the Bar Association. So BCCE therefore talks about the defense and the protection of the honor and the rights of this. Shall I slow down? The speaker asks. The moderator constantly warns her. I have still not come to the persons shut up for different reasons. I'm saying something for those who are lay people, not jurists. It's not a matter of going there for an honorarium. There may be legal and physical consequences for the person because the person is shut up, and therefore we have to really bring the person to a situation where they can feel safe and undertake their defense in front of the courts. And as the professor said, and Professor Idil will be also saying this, legal aid is an instrument that has to be used in all the different situations. When you look at EULA, I probably mispronounced this, says the speaker. Well, are you a madman, or you're really intelligent person? Are you a small girl? Are you this or that? You need to receive the support that you need at that moment. And so a legal aid system is very important. This is a guarantee for the suspect. I'm not a student of Faruk Erem, but I have read his works, and I grew up in professional training courses. There is only one thing that is important, and that is you are of use to that person. You should not injure that person. And the condition here is it really prevents discrimination. It brings all kinds of guarantees, and and then there are other rules regarding the provision of legal aid. This has to be a lawyer. Lawyers have to do whatever they can. There are certain professional principles. Other people will be talking about this. We, the usual suspects, but we are always the others. We have always been otherized, and who are standing, always trying to stand by those people who are others. This kind of lawyer, doctor, medical doctor, and other experts that I need not enumerate here. Shall I go slower? Well, these people are, being indicted or accused. What do lawyers do when they go to people who are accused? Now, being shut up, being closed, where does this come about in the European Convention of Human Rights? We see that there are two conditions. There is a systematic approach in the convention, and one is absolute rights, and the other one is conditional. Now, if it's a matter of slavery or things like this, the person, if they come forward with this, they really can go to the state, and the state has to guarantee a trial process on the basis of this, according to Article 13 of the Convention and Article 40 of the Turkish Constitution. If you go and if you are a victim whose absolute right has been limited, you have your right to go to the state, and first of all, the state has to comply with its negative obligation, and then the person has to set the rules that applies to themselves. The second is to protect. The second obligation of the state is a positive one. This is protecting the person from assault. To look into the case, doing the investigation correctly and in the speediest possible manner, and then take them before the court, and the other person, person who has violated the rights of this person has been trampled upon. Well, access to justice, I said this a moment ago. Article 6, only in paragraph 1, talks both about victims and people who are under suspicion. There are only 4 rules here. This is fair trial and due process and being tried in a reasonable time, space, etc. There are certain rules here, and these rules are very important. The decision has to have rule. The court has to proceed on the basis of the equality of arms and in a dialectic manner where thesis, antithesis, and synthesis come together. So if you look at the United Nations Convention, it talks about the access to justice in an independent manner. On the other hand, the convention has Article 13, and where there are accusations against people, Article 6. So there is this, in the second paragraph of Article 6, there is the presumption of innocence, and in the third paragraph, there is the right to defense. Here, learning the accusation, to be able to defend oneself, to be able to use the services of counsel without payment, to be able to enjoy the services of a translator, etc., etc. But what is priority here, and for which group of people, and how are we going to make it possible for these people to access these? So the question of where does the problem of access to justice derive from is another question. The second question is, how does the state establish a mechanism for this purpose? This is a different question. We all know that the European Court talks about public order and public ethics, which is valid for all 47 members, and this, it says on this, where there are relative rights which may be limited within the scope of the convention, European Convention of Human Rights. And then, of course, there are questions of, is there a limitation that is based on law? Secondly, it has to have a legitimate reason. It has to be proportional. And then the reasons for limiting it have to be enumerated. Now, we're talking about people who are confined. Now I go to them. The fundamental source here is Article 36 of the Constitution. So this is a concept that goes beyond the right to a fair trial. Now, if we go to the Convention, Article 5, in 47 members, there are 6 reasons for confinement. One, to be under accusation. Second is the execution of a court decision. Third, an obligation to be executed. Then there is the surveillance of the development, the rehabilitation, etc., or education of a minor. So this person is put in a place. Then there is the mentally diseased, or people with mental problems. Well, when this question is taken up in the human rights field, this is different. In the criminal code, this is different. Does this person have the capacity to understand the consequences of their act? Who can understand this? A lawyer can't, a jurist can't. They can only decide in the last analysis, but then you have to have social service experts and health experts who have to work with this person in order to decide whether the person is really mentally disturbed. I have still not gone into my topic. Criton jury called me a betrayer, because psychiatrists should really look into all matters. Psychologists and others should take up this place behind them, under them. But I was saying that even judges could come in. How many years ago did I work on this? Well, 28 years ago. There is still no law on mental health. With respect to the persons under confinement, I'm now going into the topic of my presentation. Article 432 of the a law number 432 is used, and then there is also the law number 5395. Now, in these cases, with respect to the access to justice of the people who are confined, with this, the law on the protection of children is a role model, so to speak. If the child is brought with the claim that they are being abused or assaulted, then they are immediately put in a protection unit where they will be protected. This will be the juvenile court will be notified in 5 days, and then on the basis of the report received from social workers and health workers, there is a decision made. Now, when you look at the civil code with respect to people who are drug addicts, etc., this says, well, this is based on the confinement of the person is built on the decision of the justice of the peace. Well, you only listen to the person, where people on the field will know very well, for instance, that with bipolar condition or manic depressive state, and how do you listen to them and the schizophrenic person? How do you explain to them their own situation? How will you explain to them why they are confined? This is really a field of expertise. There is the mention of physicians, medical doctors in both laws. But the decision is left to the justice of the peace. What happens then? The reports come. These reports are supervised in regular, periodic manner. But how long will this person be confined? How often will the reports be made? Will there be a lawyer next to the person, or who will be the consultant for the patient, which was proposed in the draft of the mental health law? And if you are under suspicion of for a certain act, then the right to provide evidence, etc., is given, but if we're talking about this person as a drug addict or a mental health, if this person is confined because of this involuntarily, then what kind of ceremony will be done during the confinement? This is not really taken up in the law in effect. Well, the justice of the peace perhaps will not listen to you, and for months or years you may remain confined in an institution for years. If you are under custody, if you have a custodian, then of course the person has the authority to confine you. The judge even does not know about this, and the civil society cannot complain about this. I have not been able to go into any details, and my time is up. So I would like to invite the Association for Equal Rights to work on this in a special manner. Then we will not only brush the dust of the topic, but really go into the intricacies of it. But there are problems of communication. Let me also talk about the following. With respect to drug addiction, there is a very, very bad process going on. Even the minister admits this. This is the kind of Turkey that we're living in. Police stop people on the street without reason. It makes the person speak, and then if it finds drugs on the person, and even if the person is not a pusher, they are accused for engaging in the trade of drugs, and these people are forced to be in a position of accusing others by confessing to their offense and crime. In other situations, there are not even court cases opened. The person is really given a chance to rehabilitate before they are shut up in prison. Well, the public declaration of the provision is postponed in certain cases, but is this really human? When we look at the action plans of 2014 and 2019, we see that those people who are drug addicts or mental health experts are not taken up there. I have spoken too long and I have said very little. I'm sorry about this.
Evet, anladığınız gibi biz hukukçular dertliyiz.
As you very well understood, we are in need of talking a lot, we jurists. It is very difficult to tell us to stop. We have many problems. By considering the lunch break, we try not to take too much of your time. And our last speaker is Betül Durmuş. She's from Koç University, and she will talk to us about children before international human rights bodies, representation or direct participation. And she was a rapporteur for Oxford University, and she received her PhD from Koç University on children's rights, parental rights, and she graduated in August 2022. And she was a researcher at graduate level, and her areas of interest are UN conventions and their effect in Turkey. And I would like to give the floor to her. I hope you can hear me well. Good morning. First of all, I would like to thank Association for Monitoring of Equal Rights, Atılım University and Union of Bar Associations of Turkey for their invitation. My presentation will be on a very specific topic, and it is about the access of children to international bodies, and I will try to cover this in a limited manner, because international mechanisms and the jurisprudence is getting more comprehensive in years, and that is why I will try to limit my presentation to instances, to cases where there is overlap of parental and children rights. And if there is a suspicion of abuse from the side of the parents, I will try to focus on those cases mostly. So for these cases, as regards to the access of children to international bodies, there is direct participation versus representation. I will primarily talk about the representation by parents and the conflict of interest that might result from this representation. Then I will talk about the best interest of children and their right to participation. And then I will talk about the solutions to this conflict of interest and the possibility of individual representation and direct participation, and the international organs listening to the child. If the child cannot be the applicant, there is the possibility of parents representing the child. International law gives the authority to represent the children, and in instances where there is a suspicion of neglect or abuse and where protection of the child is necessary, there is a conflict of interest and the topic becomes controversial. And how is the situation about the applications to the Children's Committee? Convention on the Rights of Children and the optional protocol includes certain regulations, and in the procedural rules there needs to be guarantees that will prevent the manipulation of the child. If the applications are not found to be to the best interest of the children, this can be prevented. And there can be application without the direct approval of the child. However, the applicants who apply on behalf of the children need to justify their application. And when we go to Africa, the Committee on the Well-being of Children tells us that the best interest of the child needs to be proven. However, in the implementation of international human rights, conflict of interest is not dealt with in detail. For example, United Nations, and when we have a look at the practices of the Human Rights Committee, there is New Zealand and Chola Canada decisions. And we see that the committee allows for the representation of the parents without discussing the conflict of interest. In the Cholach Canada case, the representation by the parents was linked to the bond between the mother and the child. When we have a look at the European Court, we see that conflict of interest, the possibility of a conflict of interest, is being discussed recently, and it became an issue of admissibility. And in many decisions, like Moser and Austria, in such decisions, we see that for better protection of children's rights, there was the reasoning of the parent representation. But I am directly quoting that the child's interest and the individual assigned to serve as the voice of the child, if there is a conflict in between the two parties, the best interests cannot be presented to the court, and there is the danger of not serving the best interest of the child. And although the biological mother is representing, this jurisprudence started to change as a newborn baby case. In the judgment in 2019, we see the jurisprudence of the European Court of Human Rights being changed. The conflict of interest between the child and the parents was seen as a reason for inadmissibility, and then we have other judgments like Pedersen and others, Norway, EM and others, and Norway, in which we see this interpretation being continued. And we might talk about a dilemma as concerns the access to human rights or organs. On one hand, there is the possibility of not accepting the parent being the representative. And this brings forward the risk of not hearing the claims by the international organs. And if the parent is the only party to represent the child, then it might not be the best representation of the independent interests of the child. And the possibility of a conflict of interest should definitely be evaluated in detail by the international organs. So how can the international human rights organs solve this problem? So, is the only solution to find the case inadmissible in the presence of conflict of interest? I will discuss some possibilities here. However, the resources available to these organs can be limited. The principle of the best interest of child should be interpreted together with the participation of the child, and national bodies can monitor to what extent international bodies serve this purpose. And the child has the right to freely express everything that will serve their best interest, either directly or indirectly through a representative. The child is given this right. And United Nations Committee on Children's Rights talks about the principle of best interest and the participation of child, and they see these acting together. So between these two, we see a very strong relationship. And as a good example to the establishment of this bond, we can go to the Inter-American Court. And in this case, there was a lesbian mother, Atala Rifo, and her partner, and they were living together with the daughters, and this might have resulted in a confusion concerning sexuality and gender. And there were these accusations, and the mother was deprived of the right of guardianship, and it was given to the father. But the children stated the fact that they wanted to live together with their mom at the first-degree court. However, the higher court gave the decision without listening to the children. And the Article 8 is the right to fair trial, and listening to children and hearing them is an important aspect of this, and the Chilean court was seen to not listen to these children. The fact that children have not been listened to cannot be a violation in itself, because in instances where there is neglect or abuse, having the child repeat these occurrences might further traumatize the children, it was said. The main problem in Inter-American Court is that children speak about certain things, and in the first-degree court these were listened to. However, the decision, the judgment by the higher court was in opposition to this, yet it wasn't justified. And we see that the best interest of children and the participation of children are complementary to each other. And when we have a look at the practices of the European Court of Human Rights, there are many references to the best interest of children. However, participation is not seen as an independent right, and it is not used to a significant extent in its jurisprudence. The participation of the parent in the process and hearing the parent by the national authorities is in practice, and it is seen as a procedural right stemming from Article 8. However, for the children's participation, this is not available at the moment. Then, at a limited level, the European Court sees not hearing children as an additional factor for violation. Concerning the conflict of interest, I talked about a dilemma, and surmounting this problem might be through representation by individual parties. And in my presentation, I will not be tackling whether this is possible at a national level, but rather would it be available at international level. And in the optional protocol about the admissions, this topic is not regulated in detail. In the Convention on Children, Article 12, there is the possibility of listening to the children through an indirect representative. And the Committee on Children's Rights, in the general interpretation, makes a brief evaluation saying that there is the risk of conflict of interest between that independent representative and the child, and representatives should only be representing the interests of the children, it said. the issue of independent representation is explicitly regulated in the European conventions, and in the European conventions on children, for the protection of children against sexual assault and abuse. This is seen as a possibility that can be made use of. So can international organs do this? And can they assign an independent representative for children? This is an important topic, and this is a discussion that is ongoing between the judges of the European courts. As a first in its jurisprudence, in a judgment, EU-Croatia, between the parent and children applicants, there was the possibility of a conflict of interest, and there was an independent representative assigned from the National Bar Association. There was a request in 2019, and this was based on the procedural laws of the court. And when we have a look at these, we see that in Article 36, it says that somebody approved by the head of the chamber can represent the child. So this practice, on the other hand, was criticized by the judges who do not approve with this decision at the EU level, and also by the Croatian court, saying that assigning an independent representative would not guarantee a better protection of children's rights at all instances. Independent representation at the European Court level in the Steinlob and Norway decision was revisited, and the judges said that in children's protections cases, the interests of parents and children are different, and these cases bring forward different human rights for children and parents. And with a child-centered approach, for a child-centered approach, they defended an independent representative, and the court had to come up with an amendment in its procedures to allow for this. The issue of independent representations and whether the European Court can ask for this, at the moment this is being discussed together with the procedural rules. And representation of children by parents or independent representatives. Lastly, there is the possibility of direct participation by children and by the possibility of being heard directly. On the convention, there is the optional protocol, and Children's Rights Committee directly listening to children. There is no such provision. So can children participate in the hearings, and can they be directly listened to by the committee? There is no direct provision, but according to the accepted procedures, children can be informed and their opinions can be heard depending on the age and maturity it stipulated. And the children can as well participate in the hearings, and child-sensitive measures will be in place, and age-appropriate measures will be in place. And we are again going to Africa, and a panel of experts on children's welfare said that for effective participation of children at the court, relevant procedural rules will be in place, and these hearings should be carried out in a child-friendly manner. When we have a look at the committee judgments so far, they talk about the independent individual applications. However, we have not seen so far these committees inviting the children. There was a very famous case concerning the climate change, and child applicants could join through online means, and child-sensitive or child-friendly procedures and how they will be functioning. These have not been clarified so far. When we have a look at the Inter-American Court, again going back to Atola Rifo case, so representation by parents. The children need to give consent to this, or there wasn't any application for being present at the court. And in that specific case, based on the information found in the judgment, the children were at the ages of 10, 12, and 17. Their developments and their knowledge and experience could differ. So their opinions should have been were obtained in the presence of a psychiatrist in an environment where the parents were not there. So child-friendly procedures and what these can be was given in the practice of the U.S. court. Lastly, in these cases, as concerns the child reaching the international organs, there is either representation by parents, representations by an individual representative, or the child participation by themselves. And we do not see a unity. Sometimes conflict of interest or asking for the opinions of children is conducted by some, but not by the others. And jurisprudence about children's rights continues to grow and diversify. And in the coming years, we will be guided further by these practices. Thank you very much for your attention. If you have questions, I will be more than happy to answer them. Thank you very much for respecting the time. We do not want to close before allowing for questions. And we will be discussing disadvantaged groups throughout the day, and there will be the opportunity to have questions later in the day. But if you have burning questions, I can easily give you the floor.
Tamam, 3 soruyla sınırlasak olur mu o zaman?
Can we limit the questions to 3, please? Hello. This is not a question. I would like to comment. And perhaps this could be a point of view that should be expressed, because I think this will be a contribution to what Aynur Hanım said. Well, not a contribution. I think it is that what I'm going to say is related to what has been discussed on confinement. Well, with respect to confinement, the question of persons with mental disabilities. I am an expert psychological consultant. I work in schools. The highest number of situations that we come across even in preschool or primary school years, the individual has been labeled and has felt totally lonely. And a small child has had to struggle with the labels put on them by adults. And in general, this has its origin in the teacher being in a comfort zone within the classroom. Well, and then the question of assumptions of damages to be done by the child. There is an operation on perception, then labeling and guidance, special student classes, special student or special education schools. And they are more and more pushed into a narrow community. And I have been in this field for 26 years. Usually these kids are not where they belong. They're pushed into that situation. Of course, how does law operate? Does this come within this scope? And I think this is close to what Aynur Hanım talked about. Is there any work done in this sphere? I would like to be enlightened. But there are victimhoods in this area. In my class practice, I say, for instance, one child is left alone and made the other. I say that let's put in a camera within the class so as to prove that it's not because of this child alone that we arrive at this situation. And this really has its impact on education. And when we go to courts, nothing is done, really. I would like to receive some support on this in this area. Well, there is another person behind. Well, I have the mic, so I have the right to speak, right? Thank you very much. It's very interesting. Kasım Akbaş is my name. All speeches were very interesting. But there was a reference to the last session. There's a need to talk about this, a certain topic. With respect to the mechanism on the question of legal aid, and then there is the appointment of a lawyer. That's another mechanism, appointment of a lawyer for criminal trials. These are two different things, and there was a reference to bar associations. That's why I felt the need to take the floor. For instance, our colleagues who work in the appointment for criminal trials, when we do some work on the honoraria paid to our colleagues, we think that they are very much underpaid. This may seem to be corporativist in the sense that we are looking the interests of lawyers, but then it has its consequences, of course, for the defendants as well. There are many things to say, but I don't want to, speak too long. In particular, in Ulaş's presentation, I do understand, and of course the topic has to be taken up in a very broad manner, but there is Article 180 in the law on lawyers. Now, I'm leaving the appointment of lawyers for criminal trials aside. I now come to legal aid. Sometimes, we are 1.5 years too late in receiving the salary or fee, for this service or sometimes even 2 years. Of course, this is not a question to be solved only on the basis of fees. Well, Article 180, Paragraph 1, Subparagraph A, after certain deductions, 2% will go to the Legal Aid Bureau. Up until, very recently, in 2007, this was 3%. This was brought down to 2%. Simply to raise this again to 3%, or given the increase of population, to raise it to 4%, at least part of the problem can be solved with respect to legal aid. I'm not saying the whole thing, but a part. And then there are very different projects by the bar associations and the union, and these are for, of course, assisting, helping people in need of legal aid. And I want to ask Aynur Hanım, you're right, but I thought, how can this be done? I was appointed for criminal cases myself. When you go to the police precinct, when you go for their expression, the person who is giving his statement looks at you, where do you come from? Because they don't know. But how can they be notified? Because they are under arrest, and they have been detained, and there is also only the system only establishes links between the law enforcement and the bar association. So how can you reach out to the victim or the suspect if you have a solution to this problem? Please, I remind you that this is only the introductory session. We will have time for questions in other sessions. One more question was asked. We cannot hear anyone speaking.
First of all, thank you so much to all speakers for your very inspiring presentations. And I have a question for Ulat. I understand that legal aid cases are very unpopular with Turkish lawyers because payment is low. And I wonder if in the future it is planned to create some incentives to encourage lawyers to take up more legal aid cases, and if not, do you have an idea how such incentives could look like? Thank you.
Evet, son bir soruyu ben atlamıştım.
Çok
Peki,
teşekkür
son
ederim.
olsun. Buyurun.
Öncelikle tüm konuşmacıların
Thank you. I would like to thank all speakers for their very frank criticism with respect to the practice. I have another question. The Constitutional Court cancelled a certain provision lately. Kerem Altıparmak had a debate on this on social media. When you look at the content of the decision of the Constitutional Court, yes, Kerem seems to be right. But then, when you look at the realities of Turkey, I feel myself to be on the side of Kemal, Professor Kemal. So what is your opinion on this? Is the president of the Diyarbakır Bar Association here? The Committee of Ministers changed the statutes, and perhaps here too there can be some amendments. Well, if there are certain changes made to the statutes, then including Kasım Bey's question a moment ago, many problems can be solved. Well, I don't know your name, dear lady, but I, gave birth to my son when I was 39, I have been working on children's rights since then. I worked on children who had been victims of torture, etc. What you said is true. The confinement is only the apex of a whole process. When you draw a very broad arc, there are other stages of this. But when we look at the European Convention of Human Rights, there is someone here which is for whom proceedings are continued, executed according to certain violations of rights. I was not even able to go into my topic. Well, what you're talking about is the great confinement. That is to say, it's like being changed to a certain inside a building. This is the great confinement in the sense that this is not, you're not shut up in a building, but socially confined. There was this child who had won the exam for good schools, good high schools, and he had a certain disease which was very far away from his home, but then he was sent to another school which was closer to his home, and Recep Tayyip Erdogan had started this in 2010. In 2019, this child was sent to a school which was of the same type but closer to home. So without a quota, these children were sent to the home of to a school near his home or her home. Many people criticized us. The Parents Association and everyone in the school really attacked us. This was an adolescent with their sexual development, with their bodily development, with their mental development. This disease was totally related, and the child was made into an object of hatred. But the reason was because the parents were too much focused on points. Yes. If you're atypical, you're called autistic, you are called a drug addict, you're called a mad person, etc. And then you should be sent into a place where you can be under control and transformed into a useful person. So I agree with you. I think very deep process of research will be taken up on this question. Well, with respect to Kasım, well, I was really given the duty of looking after the robots, but I was dismissed because I was against robots. That's why the police uses robots. Why did we establish the lawyer appointment system in the criminal procedures law in 1994? The reason was torture. As soon as the person is taken under custody and the lawyer went, the torture was prevented. But in practice, this is not how it works, because the person is made the victim of great torture before the lawyer goes. We kept the appointment center for 24 years. Now bar associations use robots. Down with the robots. Of course, you should think of the fees of the lawyers, but we need efficient, practical, and effective kind of counseling. The person has to see the different options and be able to choose one of the options according to their free will. The lawyers and the profession of lawyers, bar associations, should support this. We have 2 days. Well, they're making me shut up, says the speaker. No, you're not being shut up. There are 2 days. First of all, I would like to answer the question of Stephanie Lemke. Well, there should be a structural change. We attacked England very much, but let's want something. The Citizens Advice Bureau, it doesn't work right after the Second World War. It doesn't work well, but it's good. This does not mean the people have to go to court. These are not important litigations, so sometimes it's very simple. So there has to be an intermediate mechanism before people go to the bar association, and so people can, go to this office in order to be informed and solve questions with Social Security or retirement or whatever. But so this way we save the bar associations from too heavy a burden, and this is much less costly. Secondly, of course, the fees should be increased. I was very deliberately, refraining from touching upon this question because there are so many representatives of bar associations in this hall, and it will be touched upon. It should not be 4%. Well, if we double it, this means that per person, the amount of legal aid goes up from 1.6 Turkish lira to 3 Turkish lira. This is nothing. So we really have to expand the services of legal aid. What can be done? Of course, the budget should be increased, and the state should not tax the fees that the lawyers are paid. This may be an incentive that could raise the motivation of lawyers. And secondly, Kasım really touched upon an important thing. You pay the value-added tax, and then you receive your fee 1.5 or 2 years later. And this will mean nothing now under the conditions of very high inflation. But I also want to criticize my own colleagues. Some of them may not be happy about this, but I think for senior lawyers, determined number of files should be sent to them every year. Well, there is the, we send doctors for compulsory work in underdeveloped areas. The youngest doctors, we should send the senior doctors. The same goes for the appointment of lawyers for criminal cases or legal aid for civil cases. We need experienced lawyers, doing 50 or 100 or 150 hours per year. And these people who are sent are for criminal case. A 22-year-old lawyer is face to face with a deliberate murder crime, and so this is really a very difficult case for them to take up. So we should have, in these cases, senior lawyers. Well, for other areas, let's talk separately because, this is not something that really concerns this audience. Any announcements? Lunch will be had one floor up. We are sorry for the delay, and we will start at 2 o'clock in the afternoon. Would you please sign the list that we have outside, putting your names and then apposing your signatures next to them? It's outside, and we need your signatures.